Jacobson, heard weekday mornings at 11 on AM 560. The Answer.
Now, from the Signature Bank Studios. If you're looking for the latest news, insight into what it means, and
Our anti-weaponization fund that we discussed quite a bit last week, including the Republican opposition to it, because, of course, the mind immediately goes to demagoguing it by saying this is going to give cash payouts to people who assaulted cops on January 6th. That's what the leftists are saying, and Republican quislings like McConnell and Tillis and others. Of course, it's not limited to J6, and there's no indication that it's just going to be blank checks per application. So the committee that's set up, the adjudicative body that's set up, will have to make these determinations, and those determinations will be subject to public scrutiny and public criticism. But it's so much broader than J6. In point of fact, interesting, Jesse Fuentes, the alderhuman who was arrested by ICE in Chicago, does she still go by she? Has indicated that she's going to submit an application to the Anti-Weaponization Fund, which she's entitled to as I think it was Todd Blanche, the acting AG, said Hunter Biden could submit an application if he wants to. It doesn't mean he's going to get paid out, but he can submit it since he claims he was mistreated by the Department of Justice. That was the basis of the big guy's pardon, right? You heard Jill Biden say it on Jill Biden, Jill, Jill Biden, say it in that interview she gave last week, the basis of the baby boy Hunter pardon after the big guy said he wouldn't. Well, he was mistreated by Biden's Department of Justice. Okay. I don't think it's a persuasive argument, but you're entitled to make it. A much more persuasive argument comes to us from our next guest, and he has nothing to do with January 6th. He's an entrepreneur. His name is Jason Cardiff. He's the founder of Redwood Scientific Technologies and VPL Medical. He wrote a piece over at realclearpolicy.com. The government took everything before it proved anything. That sounds like the definition of weaponization. Jason, thanks so much for joining us. Appreciate it.
Thank you, Dan. It's great to be here.
It's good to have you. I mean, just give us the Reader's Digest version of your story.
Yeah. So the quick version is I had a company called Redwood Scientific Technologies. We made a sort of a dissolvable mouth strip that had a very well-known active ingredient to stop people from smoking cigarettes. It worked extremely well. It's called TBX Free. And in the middle of the night in 2018, we were raided by the Federal Trade Commission. They came in. They used a law called Section 13B of the FTC Act. They froze all my funds, all my company's funds, all the employees' payroll. They put a receiver in. They shuttered the offices. And I said, what are they doing? What is going on here? I fought them.
Sorry to interrupt, but what was the stated basis for this raid and freezing of assets and so forth?
Their basis was that they said that the testing for the active ingredient, while it's extremely well known, it's not known in the mouth strip. But their basis for the freezing of assets was they cited Section 13B of the FTC Act. And they said that allowed them to put in a receiver, freeze all of your assets, personal, corporate, retirement, any other businesses you have, any accounts you're related to, and take all of that money and send it over to the receiver, which effectively worked for the FTC. That's the basis that they used. And that's the basis we fought them on.
Just on this, though, so that this mouth strip, I mean, did this have to go through an FDA approval?
So we went through the FDA process through the HPUC, which is the homeopathic process. So we were an over-the-counter product.
Okay.
Our issue was never an FDA issue at all whatsoever. I mean, the active ingredient had been studied in 20,000 people, including publications in the New England Journal of Medicine and everything else. Everyone knew how well it worked. I mean, we were helping people get off cigarettes. That was the bottom line.
So I mean, I know what the enforcement mechanism is, but they have to have something ostensibly that triggers their ability to use this enforcement action, and so the basis was to say this active ingredient is illegal or what?
They're saying the active their theory was that the active ingredient had not been tested in the strip. It's the same amount of milligrams that's tested in pills or in other delivery methods, but the basis for their litigation was it hasn't been tested in the strip.
The form of delivery for the active ingredient.
That's right, Dan. The form.
Gotcha.
That's right.
Gotcha. Okay. So they freeze everything, and then what happens?
Well, they freeze everything, and then they tell you to defend yourself, and you go into federal court and ask for money for litigation, and every dollar you have is frozen. They freeze, and they don't give you any of your own money. They don't give you your money for your bills. They don't give you money for food. They don't give you money for health care. They don't give you money for your own legal defense. They take all of your money before you've even had a hearing, before you've even had a trial. You're completely captured under the way that the FTC acted at that time.
And this is in federal court, or is this an administrative court, or what is this?
No, you're in federal court. You're in United States District Court in front of an Article III federal court judge.
And so how do you pay for your defense? I mean, did you represent yourself pro se?
You first, because we had corporate defendants, you can't represent yourself. You've got to work with groups and funds. And luckily, I had a lot of people that rallied around me and said, "This is just ridiculous." We had no financial wrongdoing in the company, and this is what weaponization looks like. This is true weaponization at its core. And there was no reason for them to do that. And the story gets much worse than that, because I did figure out how to get representation. And I said, we're going to fight these guys as far as we can go. And coming into 2019, I realized, well, I need to start a new company. And COVID was coming around. There were hints of it. And I realized no one in the United States was manufacturing surgical face masks in the U.S. So in California, I built the first and largest 3-ply surgical mask factory. We were able to employ, upwards of 400 people and make millions of masks. And so what does the FTC do? They get wind that I now have a made in the USA surgical mask factory. It's coming into 2020. We're getting ready to get locked down. And we don't want foreign source material from China. We don't want PPE from China. We want made in the USA goods. Now that's what the country's all about. As a matter of fact, it's not being reliant on a foreign sourced medical supplies. And so what do? They get a second injunction and a second asset freeze against a totally unrelated company.
And this
went back to court.
And I mean, just not to jump ahead, but the context of this. So you were awarded this VPL Medical company that you started, the mask company. You were awarded a $14.5 million contract to deliver 20 million American-made masks to the Strategic National Stockpile. So you were essentially vetted as a contractor by the Department of Health and Human Services and awarded this contract, and then the FTC comes in after that?
They come in after that. That's right. They found out there's a new contract, there's new money for them to get, there's new damages for them to cause. And after Health and Human Services awards us a contract for the National Strategic Stockpile, including I was dealing with several other branches of the U.S. government that needed face masks. They didn't want masks from China. Those masks were coming in with particulates in them and weren't to be trusted. We were employing people, paying an incredible wage and building a factory in the United States. And they came in after that and took that over as well. And so what do you think they did? What the FTC's decision was, as the peak of the pandemic is hitting and they've now got a second injunction and asset freeze, they decide that they're going to close the factory for 3 months to evaluate how it can operate while people are dying.
So they point. I mean, I don't even get into masks, but I mean, but the receiver. So they appoint another receiver to this mask company.
Same receiver.
And he
same
can't.
Receiver, Dan.
Oh, same receiver. So same receiver comes in and he cancels that contract, and he basically shutters the company.
He shutters the company, and I said, look, I'm not about getting into masks whether they're right or wrong.
Yeah. I get it.
The one thing that is right is we need to manufacture in the United States.
Yeah, fair.
We don't need foreign sourced PPE. We don't need foreign sourced medical supplies. We need to make sure we're self sufficient as a country.
Okay.
So he cancels the contract. They close the factory. Hundreds of people lose their jobs. And they then come to me and said, if you agree to pay the receiver $25,000 a week, we'll let you run the factory. This is after it had been closed for 3.5, 4 months.
Well, wait a second. If you pay the receiver $25,000, we'll let you run your factory. Well, then what is if you can extort $25,000 out of me on a monthly basis to run my factory, then what is the underlying violation of the company that I'm not paying you $25,000?
There was no violation of that company. That company had no violations whatsoever. I mean, for that matter, I would tell you that the original company, Redwood, had no violations. This is what real regulatory capture looks like.
Wow.
And so what did we do? We went with another case with all the way to the U.S. Supreme Court and fought the FTC. And that was on the issue of, does the FTC have the power to take all the money from private citizens and companies without a trial under this Section 13B? And that came back a unanimous 9-0 decision against the FTC.
Supreme Court 9-0,
so,
right?
9-0. It was 9-0. It was drafted by Justice Breyer. It was the last decision he drafted. But when you look at weaponization, the damage is now done. It's 4 years of litigation. It's a shuttered mass factory. It's a shuttered pharmaceutical company that had an incredible product for people to stop smoking. But how do you go and get all that back? How do you get your bills haven't been paid? The damage is so widespread. It's hard to get your hands around.
Yeah, as you write in your piece, I mean, this is a version of the punishment. The process is the punishment. You write in your piece, you win and you're still destroyed. Which is right. Yeah. But let me just add this. So see the argument I've gotten into, like with Andy McCarthy last week, with friendly discussion, but this is the perspective. Well, in a case like Jason's here, of course he has an avenue for relief through the federal courts, and that's why you don't need the anti-weaponization fund, because he can just seek redress through the federal courts, which you tried, and how did that go?
There's no redress process through the federal courts because the FTC has sovereign immunity, right? So the answer is to go to the FTCA, the Federal Court Tort of Claims, the FCTA, the Federal Court Tort of Claims, is that the Federal Trade Commission operates under sovereign immunity. And if they made a mistake for 38 years, taking billions of dollars from people unlawfully, then they made a mistake. That's that. Sorry, you get nothing. We understand that a lot of damage was done, but there's no redress pathway for you whatsoever. And
I mean, that was it.
That's it. That's it. Yeah, it's sovereign immunity. And the FTC and its lawyers operate under sovereign immunity. So there is no pathway. That's why the weaponization fund with this type of weaponization becomes so incredibly important. The damage that's been done to myself and my family and my companies, it's probably one of the most un-American stories you can ever hear. You would never, if you told someone this story, everyone says, well, how's that possible? How can they do that?
Right.
They did it.
That doesn't happen in America. Well, it happened. You write here, too, that 6 fully brief motions to dismiss covering fraud on the court, due process, double jeopardy, evidence suppression, all been denied by a district court judge who's an Obama appointee. Every player in this case, you write, with the exception of myself, is a Biden or Obama appointee. This is not coincidence. So, I mean, this is everybody covering everybody else's backside to keep everybody's fiefdom up and running. And it doesn't matter that, for example, FTC wasn't communicating with HHS or didn't even take judicial notice and concerned that you were perceived to be a legitimate contractor to the tune of $14.5 million for the mask from HHS. That didn't matter to the FTC because we do our own thing over here. We don't care what they do.
They had 40 years of unchecked power, which is why agencies are so dangerous. For 40 years, they had gotten away with this. And the Ninth Circuit, especially, which is where it started, actually, the district courts just kind of all go along with what all the rest of the district courts are doing, and that's why agencies are so incredibly dangerous.
And the Supreme Court's ruling was limited to the FTC's ability to impose penalties. But I haven't read it, so I'm assuming it was silent on the issue of recompense for a wronged party like yourself.
Yeah, it didn't address that, and it's interesting. So as you know, you go through the court system. We go back to the district court, and the district court says, listen, I've never had to give a company back from the FTC. Mr. Cardiff, here's your company back. You don't owe the FTC any money. While we had a receiver in there collecting and spending all of your money on all of the expenses and shutting down companies and making all of your financial decisions for you. I wasn't able to pay life insurance policies. I wasn't able to pay school bills. I wasn't able to pay. They denied me from being able to pay child support. Okay. I wasn't able to pay anything with any of my own money. But yet, all of a sudden we realized the Supreme Court has ruled that was never allowed. So there's no pathway back. And to make matters worse, I kind of go into the story, which is, President Trump in great wisdom in his first term told the Department of Justice that we then created a policy called the No Piling On Act, which effectively says if an individual or a company has been through litigation civilly and that's ended, then you can't go after them again for the same issues on a criminal manner. But that's not what happened with my case. So two years after finishing the issue civilly, the DOJ the DOJ decided to come after me personally, criminally, for the same adjudicated issues we just went through with the FTC.
After the Supreme Court decision.
After the Supreme Court decision, 2 years after the case was over, they decided they'd come after me personally for the exact same issues that we went through with the FTC.
So you were criminally indicted as well.
I was criminally indicted 2 years after we closed the civil case. They decided to take another bite at the apple against me.
And how did that play out?
Well, we're playing that out now. I mean, as I said, we have an Obama appointee as a judge in the criminal case. We've got 6 motions he's denied. And I'll tell you, to make matters worse, it's the only criminal case in the United States where the assistant United States attorney left the case a year and a half ago. There's no assistant United States attorney in this case. There's a DOJ trial lawyer who doesn't have delegation of authority to be in the case, and we filed that over 30 times with the district court, and the judge ignores it. He doesn't even have the statutory authority to be in the case.
This is astounding.
That's weaponization.
Yeah, I would say. I mean, this is really astounding. I don't know how, you can you get to, one of the congresswomen to get to, Blanche at DOJ and say, you need to take a look at this case?
We filed it's difficult. There's a lot going on at DOJ.
Yeah.
We've obviously filed, I think we're probably in the top 5 or 6 have filed our weaponization documents, but we start the document off with this weaponization is current. It's happening right now. It's not like it was happening.
It's still happening.
Going on.
Yeah.
It's happening, and it's happening in the absolute worst way, because if federal courts allow DOJ trial lawyers to start litigating cases without U.S. attorneys, you've opened Pandora's box to some of the most you could see criminal cases all over the place about everything.
Yeah, Jason.
You can have a Washington, D.C. trial lawyer take it over.
Jason Cardiff, we're going to have to leave it there. Thanks so much for joining us. Appreciate it. Good luck with your weaponization claim.
Thanks, Dan. Thank you, guys.
And Jason joined us in the alphawealthgroup.com answer line. It's now 7 o'clock on AM 560 WIND Chicago.
He insists Iran really wants to make a deal. I'm Dave Anthony, Fox News, and President Trump